We know that mediation is often required prior to adversarial judicial proceedings. But what if mediation fails? Can the mediators later testify as to their potential recommendations? In the 1983 California case of McLaughlin v. Superior Court, we examine these questions in the context of a local court rule that required mediators to provide the court with their recommendations regarding disputed matters. Thomas and Linda McLaughlin were married in 1969 and had 3 children. In 1982, Thomas filed for divorce in California Superior Court. California Civil Code requires disputed custody and visitation matters in a divorce to be addressed in mediation prior to judicial involvement. It also provides that if mediation fails, the mediator may provide a custody or visitation recommendation to the court, consistent with local rules. Pursuant to this law, the California Superior Court established a local rule which 1. Required the mediator in such matters to deliver a recommendation to the court if mediation failed, and 2. Prohibited the parties' cross-examination of the mediator regarding the recommendation. In his petition for dissolution, Thomas requested custody of the children, and Linda filed her response requesting joint legal custody and primary physical custody. Based upon an understanding that the custody and visitation matters were to be referred for mediation, Thomas alleged that the local rule precluding cross-examination of the mediator regarding the basis for the recommendation was unconstitutional. He moved for a protective order to preclude the mediator from delivering a recommendation to the court if mediation failed, unless cross-examination was guaranteed. In accordance with its local rule, the court denied the motion. Thomas petitioned the California Supreme Court for a writ of mandate and to stay the Superior Court's custody and visitation hearing in the absence of such a protective order. The state Supreme Court stayed the hearing and referred the matter of the local rule's constitutionality to the California Court of Appeal.